Welcome to SB&M is Here, the State Bar of New Mexico's official podcast. In this series, we'll discuss topics such as professional development, tools of the legal trade, and mental and professional well-being. Connecting the legal community across New Mexico, SB&M is here. Hello, everyone. Welcome back if you listened to our first episode regarding COVID-19 being a forced life transition for our legal community. If you are a new listener, welcome to SB&M is Here. If you haven't listened to the first episode, it and all episodes will be available on the listening platforms of Spotify, iTunes, Google Play, and YouTube. Make sure to subscribe on your preferred platform to receive notifications when a new episode is ready. And just a brief reminder about the podcast, we hope to cover a wide variety of topics, and because of that, we've created different episode categories. At the start of each episode, also in the episode title, we'll indicate what type of episode you'll be listening to. To save airtime, you can read up on the different categories at nmbar.org/podcast. While you are there, you can request to participate in an episode and also rate and review this one. Pretty please rate and review any episode you listen to because we want to tailor the content to you. For this two-part episode, we'll be discussing tools of the trade. We'll hear discussions from a past Young Lawyers Division Chair and hear about her experience and insight regarding a variety of topics. The first episode will dive into day-to-day relationships and everyone's favorite topic, money. The second episode will discuss work-life balance and personal professional growth. Both episodes will be presented by two incredible women, and we are very lucky to steal some of their time. Allison Block-Chavez, the current YLD Chair, and Ernestina Cruz, the current Bar President and previous YLD Chair. Ladies, welcome, and thank you so much for being here. Feel free to introduce yourselves and take it away.
Great. Thanks, Morgan. Hello, everyone, and welcome to the Young Lawyers Division podcast series, What I Wish I Knew. I am Allison Block-Chavez. I'm an attorney in Albuquerque, and I'm currently serving as the New Mexico State Bar's Young Lawyers Division Chair. Joining me today is Ernestina Cruz. Welcome, Tina.
Thank you, Allison. I'm excited to be here.
Great. Tina currently serves as the president to the State Bar of New Mexico. She is a solo practitioner and owner of the Cruz Law Office in Taos, New Mexico. She focuses her practice in the areas of civil rights, employment law, and personal injury. Tina is a graduate from UNM for both her undergraduate and law degrees. She also has her master's degree from University of Notre Dame. Go Irish. She is also currently attending the Strauss Institute for Dispute Resolution at Pepperdine University School of Law, where she is completing her coursework for the LLM. Tina has worked in a law firm setting and as a solo practitioner, and I'm hoping today she can share with young lawyers her experience and any practical approaches that she uses in her daily practice. The four areas of topics that we'll be talking about today are day-to-day relationships. These are relationships with colleagues, judges, and in the office. Money, so billables and expenses of a law firm, and we'll touch a bit on personal finances. Balance, finding balance in our stressful career. And growth, how to grow as a lawyer. So let's get started. So Tina, we'll start with the day-to-day relationships, and I'm just going to jump right into some of the questions that we prepared, starting with opposing counsel. So as new lawyers, we often have to work with opposing counsel who may be more experienced. Was there ever a time when you felt intimidated by your opposing counsel or had some issues that you had to work through with your counsel? What did you do?
First, Allison, I want to thank you for having me participate in this podcast. Of course, all of the work that is done by the Young Lawyers Division is appreciated by the State Bar, and we always find that you all are on the cutting edge of dynamic new programs, and I'm happy to see that you all are taking the lead with regard to the podcast, so thank you for your efforts. The question that you ask is, I think, an important one for young lawyers, new lawyers. In my view, in the first year of practice, most new lawyers, I believe, generally have a sense of intimidation as you start to get grounded in the practice of law. For me, being a first-generation college graduate and not having had someone in my family who was a lawyer, the practice of law was somewhat foreign, and it was definitely a learning curve in my first few years of practice to just get a sense of understanding as to who I was as an attorney, what my expectations were of myself, and also what I was going to expect in terms of my relationship with opposing counsel and clients. So I think I realized early on that it was important to develop a sense of confidence within myself in order to deal with attorneys who were more seasoned. 9 months into my practice, I moved from a firm in Santa Fe to Albuquerque. And the new firm that I joined in Albuquerque was really great about giving new lawyers an opportunity to litigate cases. So I found myself handling cases on my own early on and having to interact directly with opposing counsel. There were plenty of instances where attempts were made by opposing counsel to impose a power dynamic, which I was not comfortable with. So I learned to sort of deal with those situations by pulling opposing counsel aside to visit with them privately, asking that they treat me or my client with respect, to treat me in the same way that I was treating them. And I found that to be an effective way to diffuse tense situations. There was one in particular where a deposition was being taken in my office, and opposing counsel on the record kept making comments about my client, saying things to the effect of, well, you should know how it is. You're from northern New Mexico. And of course, the comments had absolutely nothing to do with the case, but they were somewhat pointed or snide remarks about the fact that I came from the same area where my client was from. So at some point, it became readily apparent that this attorney was not going to stop. So I asked during a break if he could visit with me in my office, which wasn't too far away from the conference room. And when we stepped into my office, I, politely pointed out what the issue was and the fact that I didn't think it was appropriate that he was making those comments on the record, and I would appreciate if he would stop. To my surprise, when we got back on the record, he apologized for what he had been doing, and after that, the deposition proceeded as one would hope it would. I think that as a young Hispanic female attorney, there were instances where there were uncomfortable situations that came up, but I think the best way to deal with them is to address them head on, politely, respectfully, and for the most part, it was a situation that would be addressed, I think, in an appropriate manner without a whole lot of back and forth, which was uncomfortable. Again, I found that to be an effective way to diffuse tense situations. I guess I would say in my experience, by dealing with uncomfortable situations on the front end, it's a good way to develop a rapport with opposing counsel, because you're essentially setting the tone to have a working relationship, which is ideally going to be driven by respect and professionalism.
Yeah, I'd agree with you, Tina. I think just setting the tone and just acting professionally and just dealing with the issue head on has worked for me too. Otherwise, with a lot of things in practice, if you just let something linger, it just gets worse and worse. So I think that's a great approach.
You're absolutely right, Allison. One of the other things, of course, is that you can't have others be responsible for setting the tone, right? So I found that it didn't make much sense to go and complain to my supervising attorney about what was happening. I had to take responsibility for how those relationships were developing with opposing counsel. And I think what I learned from that is it was empowering, and that I found I was able to deal with these situations and confront them on my own and develop a relationship with opposing counsel, which I found to work best for me. So I think taking ownership for issues of concern is something that's really important for a young lawyer. And the earlier you start being responsible for those relationships, whether it's in your work environment or with opposing counsel, with staff, you end up finding a way to develop what your professional existence is going to look like, and that's a good thing to do early in your career.
What about when you walked into the courtroom, maybe that first year of being a lawyer? How are your experiences working with the judge while the judge is sitting at the bench, whether you're presenting your case or defending a case, or, you know, what were some of your experiences, and what did you learn from them?
As I was preparing for today's podcast and reflecting upon my career early on, that was one subject that for me I think is a bit more challenging than, let's say, your relationship with a supervising attorney, staff, or opposing counsel, because there is definitely a power dynamic that's at play when you're appearing in front of judges. You're not necessarily in a position where you can head on address some of your issues of concern. But I think it would be maybe helpful to share my very first experience in a courtroom. I was working at a firm in Santa Fe, and the senior partner at the last minute did not have time to appear for a motion for presentment. So one of the staff members came into my office and said, they need you to go to the courthouse, and there's going to be a motion for presentment. It was at the First Judicial District Court. I had no idea at the time what was meant by what they were asking of me. So my paralegal did a pretty good job of schooling me up on what I needed to do, and I immediately rushed out to the courthouse. I got there just in time, I thought anyway, and I sat in the gallery waiting for the judge to call the case. He moved through the other cases on his docket, but he never called my case. So as he concluded the hearing on the matter that he had just wrapped up, he adjourned and stepped away from the bench, and I sat there looking around the courtroom thinking to myself that I must have missed something. I didn't want to call the office and ask, what do I do now? So I sheepishly approached the judge's assistant, explaining who I was and why I was there. She stepped into the judge's chambers, and all the while I couldn't help but think, what did I miss, and how am I going to explain this to my partner? After about 15 minutes, the judge's assistant came back into the courtroom and asked me to go into the judge's chambers. That felt a little bit like being told you had to go into the principal's office when you're in elementary school. So I, again, was just thinking to myself, this did not go the way it was supposed to. So I walked into Judge Ernestina's chambers. He was, of course, very polite, but also stern in explaining to me that I needed to speak up, and he was very direct in telling me that I should not be shy. It was an early lesson for me, and one which I carry to this day. You just have to be very good about, speaking up for yourself, and knowing that when you're doing that, more often than not, you're going to be in a much better position than being called into the principal's office.
So had he called the case, or he relied on attorneys to check in with his bailiff? What
he did not. So he did not call the case, and I'm guessing that he just skipped over it. And that's happened before. You'll be in a courtroom and the judge doesn't get to you, so then you make note of the fact that you have a hearing at that time, and they'll take a second look at the docket report and realize, oh yes, let's get to that. I just naturally assumed that I was next up, and when he said he was done and he left, it was the first time I had ever been, of course, in a courtroom, and there I was by myself, and I just did not know what had happened. I even stepped out at some point, I think, and looked at the placard by the door to make sure I was in the right courtroom. It was all very confusing to me, but also a really good reminder that there's no harm in asking questions when you're in need of clarification, because it saves you that uncomfortable moment of having a senior trial judge scold you in his chambers.
I think one thing that came to my mind is that as a young attorney, you feel like you should know all of this information and have all this information because you've just completed law school and the bar exam. But then when you show up to work and you're doing things or you're out in the courtroom, you realize, wow, there's a lot of stuff I just don't know. Like, what just happened in this court hearing? Why didn't they call me? And it's simple things of just, hey, reminding the judge that you're here, or just doing a little research or asking for forms. But there's just so much that you don't realize that you don't know, and you think it's really kind of scary when you're trying to figure things out and you're like, wait, I should know this, but why don't I know what's going on?
You are absolutely right. And I think that, as you're starting your first few years of practice, expecting the unexpected is, the best way to approach things, because you can be in the middle of a deposition and the party who you're deposing suddenly starts crying, and you're thinking to yourself, oh my gosh, this person's crying. And for me, I immediately start feeling bad for that person. That would happen often when I was taking depositions of plaintiffs. And I soon learned to, walk in with a box of tissue and to have it at the ready, and to, always be, polite in circumstances like that and offer the deponent a break. But the first time it happens to you, you're sitting there, and it's a moment where somewhat like, a deer in headlights kind of experience, and you're not knowing how to navigate it. So if you're expecting things to perhaps go sideways or how you had not necessarily predicted, I think you're doing yourself a great service, because you're not going to be rattled when something doesn't go the way you're hoping it will.
That's a good point. And then let's talk a bit about relationships inside of the office, because these are probably what we as lawyers, that's our day-to-day work, is working with our superiors, working with our staff, and working with clients. So I know for me, when I first started at my firm, or even before that, when I clerked for a judge, I had never had subordinate staff that I worked with, and I wasn't sure how to work with them, or how to delegate work to them. And I was nervous because I'm a new attorney and I didn't know what I was supposed to do. So what were some of your first experiences working with an assistant or a paralegal?
Well, as I noted earlier, having been a first-generation college graduate with no prior contact within a firm setting, I entered law school not really having a very clear picture as to what the practice of law would actually look like. I, however, benefited from the state bar program, which introduced first-year law students to law firm settings. It's the Arturo Jaramillo Clerkship Program. And I'm so thankful that opportunity was available, because I was able to clerk at Sheehan and Stelzner the summer after my first year, and then was offered to stay on as a law clerk, and I worked there through my third year in law school. So that really was my first experience in a law firm setting. Of course, not having had prior familiarity with how a law firm operates, or even the hierarchy related to staffing, it was definitely an eye-opening experience. I learned early on that, of course, staff is critically important to the functionality of a law office. When you come on board as a law clerk, however, you're as close to the bottom of the law firm hierarchy as you can be. So you're not really supervising anyone, and people are generally telling you what you should be doing. But it really was, I think, something that was helpful for me because I was able to interact with legal assistants, paralegals, the office managers, and then associates and partners within the firm. So it was a good introduction as to how to work with staff, and it was ultimately something that I was able to carry with me as a young lawyer. Of course, when you're transitioning from a law clerk position to an associate position, there's a different kind of interplay that takes place. So you have to be really good about suddenly hardwiring yourself to accept the reality that now in some way you may be the supervisor, and that can be a bit uncomfortable because here you may have a paralegal or a legal assistant who's been at this work for 20 plus years, and there you are, a 20-something fresh out of law school, asking them and expecting them to do what is needed so that you can move your cases along. So there's, I think, a lot of room for growth as a new lawyer, and you need to, in my experience, get a handle on that as early as you can, because if you don't, it then ends up creating a circumstance where you may be treated as a subordinate by your staff, and of course that is not a comfortable situation to find yourself in.
The Young Lawyers Division is seeking recommendations for exceptional New Mexico young lawyers to feature in our new YL Spotlight series. Young lawyers who are doing innovative work and are making an impact in their communities may be spotlighted in the Sections Committees and Divisions Digest and via mini podcasts. If you have a recommendation for our YL Spotlight, please email yldchair@nmbar.org with the exceptional lawyer's name and what they're doing in their community. We'll then reach out to them to spotlight them in our YL Spotlight. I know one thing that took me by surprise is how much time figuring out what work to give to your assistant takes, and then making sure that once you get work back, having sufficient time to review it or revise it or edit it so that then you could get it either out in the mail or to the court. And so I know just everything is a time suck, and so if you could work with your assistant or your paralegal to get them to know the forms or to just do whatever approaches you can to save some time. I know that's been something I've worked on, just a bit more efficiency, and a lot of that comes with experience, both from the young lawyer and the assistant or the paralegal. Do you have any approaches that you use to help manage your assistant or paralegal?
As a young lawyer, I found that developing a collaborative relationship with staff was really important, because when you're just starting out, in my experience, I realized that my staff could help point me in the right direction. Again, I was lucky enough to have a legal assistant who had been in the legal field for 20 plus years, so she had a fantastic handle on the rules and process, and really served as a mentor of sorts in that regard. But then, of course, it's important to recognize that I was operating from the position of being in a supervisory kind of role. So in my experience, I found that it was helpful to establish respectful boundaries, because as the attorney who is licensed to practice in the state of New Mexico, I ultimately was responsible for abiding by the rules of professional conduct and making sure that deadlines were not being missed, and that I was, following the rules of civil procedure. So while I was able to benefit by the perspective and guidance that was being offered by my legal assistant, I also had to be mindful and aware of the fact that I was the attorney. And in that role, it was okay for me to be a bit more directive with regard to staff. To your earlier point, though, Allison, with regard to finding a way to sort of manage your assistant and the work that's being done by the assistant, I think it's really a question of just getting into a place of being comfortable with how you manage yourself. Because once you develop your routine, I think it's easy to sort of align your assistant's routine with that. And being able to prioritize with your assistant what needs to be done immediately and what's going to be completed later in the week helps prepare your assistant for what the workload is going to look like. I always found that visiting with my assistant in the morning so that we could plan our day accordingly was really helpful. If we had a big project that was going to be happening later in the week, getting started on that early on. So if we could get the runners, and those were the days where, you would do discovery and hand deliver piles of documents. Things are a little bit different now, but getting a runner to get started on making copies well in advance so that we're not clamoring to get things done at the last minute was also helpful. That's not to say that you're always going to be able to be so prepared that you're not working on things on the cusp of the deadline, but there are situations that you can prepare for in advance, and when you do that, it ends up alleviating stress that you're experiencing and then stress that you're handing over to your assistants as well. I think if you make a diligent effort to keep in mind that the resiliency of your staff is going to directly impact your law practice, you'll be able to take care of your staff in a way so that you're not wearing them down, because that, in my view, should not be how you are effectively capitalizing on what your staff is able to deliver for you. If you take care of them and you take care of yourself, you're going to end up being in this for the long haul, and you're going to end up delivering, the hope would be, better results for your clients.
That's good advice, Tina, because a lot of times the assistants and paralegals really make us look good, so we want to make sure that we're supporting them too. So let's move on to working with supervising attorneys. I know for me as a young lawyer, I got the advice where I should treat the partners or my supervisors as my client because they're going to be the ones feeding me work. So did you have a similar experience, or what did you do to effectively work with supervising attorneys?
I looked at the relationship with a supervisory attorney as one where I wanted to deliver the best possible work product, because when the time would come a week or two later to ask somebody to help on a case, I would want to position myself so that I would be one of the associates who was being asked. I think that if there's a misstep in terms of maybe not delivering on a project on time, then the attorney will think, well, that experience didn't go so well. I'm going to go and work with associate X because the person I just finished working with just wasn't particularly helpful for me. So I think that that's maybe in line with what you just described in terms of looking at the supervising attorney as a client. That's good advice, because I think you need to find a way to position yourself so that you are being looked at as somebody who's of value and who's going to deliver quality work. And there may be times where maybe you're a bit under the gun and that you're not going to be able to meet the deadline. There's no harm on, walking down the hall, knocking on the door. That's what I used to do even when we had email, because I think that interpersonal exchange goes a long way versus just relegating every communication to email. walking down the hall, knocking on the door, sitting down and explaining where you're at and the fact that perhaps you're going to need an extra day or so, to the extent that, time allows for that. But I think having good open channels of communication alleviates a lot of stress. Being good about managing your caseload, also forecasting. I'm about to finish this motion for summary judgment, and next week I'm going to need some more work. Going and, talking to the supervising attorney or other partners in the office who you're able to work with and saying, I'm going to need some work in the next week. Do you have anything that I can help you with? Versus sitting in your office and expecting the work to come to you. Engaging in a certain level of rainmaking, let's say, within your own office to make sure that you have a steady flow of work. It's going to help you stay busy and productive. It's going to help you meet your billable hour requirements. And it's also going to signify to your partners that you're there to help them and that you're willing to, put in the work that's needed to help the firm shine with the clients. So I think there are a number of different strategies that can be put at play, but I think the most important one is also recognizing that you need to take responsibility for your career path, and you shouldn't be sitting in a firm expecting to move in a certain direction without being proactive in elevating yourself within the office and being perceived as someone who is of value and who should be assigned the next case, because that's what's going to help you progress from, let's say, writing memos and doing legal research in the first few years to, taking depositions and then ultimately being assigned your own cases. You need to move things along, and you need to be aware of the fact that you have a responsibility in that regard, and you cannot necessarily expect things to come your way without putting some effort into it.
That's a good point. That really, at the end of the day, it's really us as individual attorneys that are pushing these cases and pushing our careers. And so we have to be diligent and manage our time and manage our work so that we can have the right outcome, whether it's finishing a project or advancing in our career. And a lot of that relies, in private practice where we have paying clients that come in, and sometimes, there's the old adage that says law practice would be great if I didn't have to deal with clients, because sometimes clients can be tough. How do you ensure that you provide your clients with the best legal representation?
In my first 10 years of practice, I worked as a civil defense attorney representing public entities and businesses, corporations throughout the state. Now I'm primarily a plaintiff's lawyer. So while the client interactions are different because I'm representing a different type of client, there are some guiding principles which I think apply equally on either side of the V, whether I'm representing plaintiffs or defendants. I think one of the important aspects of the practice is, client communication and setting the tone as to what client expectations should be, or giving your clients the information that's needed so that they have a really good understanding as to what the litigation process may look like. I find that in particular with my current practice as a plaintiff's lawyer. Oftentimes the individuals that I'm representing, this is the very first time that they have come in contact with a lawyer and the first time that they've been involved in a lawsuit. So there's a lot of teaching that comes into play. And in that regard, I'm, of course, thankful that as I was starting to build my practice here in northern New Mexico, I also chose to teach pre-law classes at New Mexico Highlands University. It just so happened that as I was transitioning back home, I saw that there was an opening at Highlands for a visiting assistant professor to teach the pre-law curriculum. And that experience, I think, was really helpful because I was able to teach students how the practice of law works and just, go through any number of different topic areas within the legal arena. So when I started at the same time interacting with clients, I found myself maybe putting on that professor hat and explaining, this is what litigation looks like. And I think there's an expectation that a litigation looks like what people are familiar with on TV or in the movies, right? It's something that just happens very quickly. You file a lawsuit and there's a resolution. And being able to explain to clients that, there's a process that's at play, these are the next steps that are going to happen. Early on, having that conversation with clients, I think, helps them understand what they need to be prepared for. So I'm always explaining, the discovery process, in particular deposition, because that's an incredibly overwhelming thing to have to do if you've never been a litigant before. Explaining what that process is going to be like, and then explaining what a mediation is going to be and how that develops. I think if you're able to communicate well with your clients and there are no surprises, there's a sense that they feel a bit empowered in the process and they don't feel terribly overwhelmed when you're telling them you're going to be sitting in a conference room for 7 hours and this is what is going to happen in the deposition. It's still going to be uncomfortable to a certain degree, but there's going to be a level of familiarity that at the end, they end up saying, thank you for explaining to me what that deposition was going to be like when I first hired you a year and a half ago. So I think that in terms of, the best legal representation, having that good line of communication so that there's a heart-end understanding as to what they're signing on for from a plaintiff's perspective is something that's really important.
I know in my experience, especially as a lawyer starting out, I was super eager to get work and to try different things and to take on clients. Was there ever a time that you realized that you bit off more than you can chew? Maybe a project took longer than you expected, or you took on a case that you realized later down the road you should have never taken that case. Can you tell us about one of your experiences?
Well, I think most attorneys will have had some kind of an experience where they felt, I have, as you just said, bitten off more than I can chew. I think for me, in the civil defense side, it related more to my interaction with corporate clients and in-house counsel in particular. For a new lawyer, that can be challenging because I often found that in-house counsel wanted to talk to a partner and not an associate, or as they might describe it, a baby lawyer. That to me was a situation where I felt like I was a bit out of my comfort zone in terms of how do I navigate these waters, because I'm dealing with somebody who feels like they're not very trusting of what I might be saying or what I might be recommending in some way. So I approached that from the perspective that it was, of course, important to be respectful of in-house counsel's role, but also being self-assured and letting them know that I was obviously assigned the file for a reason, and I was capable of answering any questions or concerns that they might have. That, of course, quickly transitioned into a mindset of recognizing that if I delivered the best possible work product that I could, they would start feeling more comfortable with the fact that I was their, key point of contact within the firm in particular matters. So again, I think what all of this comes down to is being able to establish boundaries while being aware of the fact that respect should always be reciprocal. And if you find that there's an imbalance, that maybe sometimes I might not be able to be the person that cures that issue with in-house counsel, but maybe that is a circumstance where one of the supervising attorneys can, help navigate things to get us back to a place where there's a feeling that things are balanced. And ultimately recognizing that I'm responsible for the relationship in terms of, if there's a deadline, I'm meeting that deadline. If there's assignment that I'm needing to send to opposing in-house counsel for review, that I am delivering the best possible written work that I can so that they feel comfortable with the fact that I should be working their files. So being responsive, providing top-notch work product, and to the best of your ability, delivering favorable results. I think as long as you're doing those things, you'll be able to get back to a place where things are feeling a bit more centered, and you continue to cultivate that relationship where maybe you're feeling like you're not in the best possible position initially, but recognizing that there are things that you can do to make things better.
Are you interested in participating in the SBNM is Here podcast? We would love to have you. It's as easy as reporting from your office. All you need is an internet connection and a phone. To learn more, visit our website at nmbar.org/podcast.
We're back from the break. It's the Young Lawyers Division podcast talking about what we wish we knew with Ernestina Cruz. And we're going to talk a bit about money. So, Tina, a lot of times young lawyers in private practice, they have to bill their time and meet certain billing expectations. Did you have to bill your time as a young lawyer, and what approaches did you use to be successful?
First, Allison, by all means, feel free to refer to me as Tina. When you said Ernestina, it made me think about my grandma, and she would only say that if she was not terribly happy with me. So with that said, yes, I did have the opportunity in law school to clerk at a civil defense firm. So I learned early on what the billable hour looked like. I essentially grew up in the legal profession learning how to bill. And in my view, I always used to tell the young lawyers in our office that billing is an art, especially in a civil defense practice. I think that as a young lawyer, you need to be mentored and you need to understand from a senior lawyer how to bill. You need to be diligent about tracking your day. When I started mentoring young lawyers, I often had conversations where they would come into my office at the end of the month and say something to the effect of, I don't understand. I get here at 8 in the morning and I don't leave until 6, and I'm still not meeting my billable requirements. I typically found that it came back to the young lawyer's inability to properly track time. And sometimes it related to a young lawyer cutting their time without first seeking guidance on how to bill a particular task, sort of this self-defeating kind of approach to billing and saying, well, that shouldn't have taken so long, when if they had sat down and asked the lawyer who they were working with, they may have understood, well, no, that actually was an appropriate amount of time. So I think if you're struggling with your billing, looking at it closely, and before you start cutting away, going and talking to a senior partner, the person you're working with, is helpful. And at the same time, being aware of the fact that you shouldn't be overbilling either, because I don't really think that helps in terms of obviously, delivering to your client a good work product. So, and I mean, there are ethical considerations that come into play as well. And if you start not really mastering the art of billing early on, I think you end up putting yourself in a difficult position down the road. So seeking guidance, being very good about tracking your day, and being aware of the fact that you do have a billable billable requirement if that's the professional environment that you work in. I think you'll position yourself to, as I used to say, mastering the art of billing. I think some figure it out much sooner than others, but if you make a concerted effort to get a handle on it, you'll be fine.
Yeah, I have to bill for my practice, and I've been at my firm 5 years, and it's every day. You really do have to be diligent to make sure you capture your time and capture that phone call and capture talking with your client. It's a practice for sure, like many of things in the law, but being diligent makes a big difference. So now you're a solo practitioner and you do personal injury work. Do you still track your time?
You're right. Most of my cases are on contingency, but I do find that tracking my time is still a good way to ensure productivity. Also, if there's going to be a circumstance in an employment case or civil rights case where we may be requesting attorney's fees, of course, there needs to be tracking of time that's taking place. I think that it's also a good measure of starting to recognize how much time you're putting into cases and what the end result is. So I think that there are some people that look at it from the perspective of, I never want to track my time. But I think that it's a good tool. And if you use it in the right way, it can help guide you in terms of just day-to-day oversight of what your productivity is looking like.
So billing's part of the business of a law firm, and as we mentioned, you were in a civil defense firm and you've now opened a solo practitioner's firm. So are there any business lessons that you've learned, either that you took from that civil defense firm and are applying to your solo practitioner firm, or things that you learned while you were trying to open a new firm?
From 2001 to 2011, I worked in civil defense practice. And while working in a firm, I don't know that I ever really focused on the business side of how a firm operated. I think I was spoiled in a firm environment because everything was built in for me. I had a receptionist, legal assistant, paralegal, law clerks, office managers, runners, a managing partner. There wasn't, I don't think, a real sense when I first started to be aware and mindful of the business side of a law practice. I also think that perhaps when I was in law school that there wasn't a really good set of curriculum that helped students think about the practice of law as a business. So when I walked into practicing, I wasn't even thinking that that was something that I had to be aware of. Of course, when you finally open your own office, if that's the direction you move toward, you very quickly realize that a law office is a business. And while you may be masterful at representing clients, litigating cases, taking depositions, writing motions, that there's an entire side of your existence that you need to be cultivating and honing in on a regular basis. So when I opened my own office, I stepped into it being a bit unaware of the dynamic of law office management, and it was something that I had to grow into, and I continue to grow into it, quite honestly, because I think that as with everything in life, there's going to be an evolution that continues to take place. Ideally, that should be what is happening. So what I've, in my view, been able to do as a result of opening my own office is able to, of course, focus on my work as an attorney, focus on my work as a volunteer within bar-related activities, but then also start developing that understanding of the operation of a law office as a business, and just trying to learn as much as I can, realizing that there was definitely a major blind spot as I moved in the direction of opening my own office. My recommendation would be for new lawyers, if you're starting out, let's say, in the criminal side of things as a prosecutor or a public defender, or even somebody that's, on the civil side of things and working for a firm, when you make that decision to open your own office, try to tap into as many resources as you can. There's plenty of blogs, there's plenty of books that you can buy from the ABA. The state bar is starting to move in the direction of developing a robust law practice management program. Learn as much as you can, talk to as many attorneys as you can, develop your business plan so that when you finally make that step, you're as prepared as you can be. And I think that those attorneys that lay the groundwork early on, maybe, a 2 or 3 year plan of, at some point I'm going to open my office, but in the meantime, you're starting to develop that framework. I think it's something that's really helpful and beneficial. I didn't really do that because I didn't realize sort of all of the different moving parts that were going to come into play. But as I was navigating those circumstances, I found myself having to learn as much as I could, and I continue to, recognize that there are times when I need to figure things out as best I can. What I think is important is, trying to learn from others who have gone through this experience, because the reality that became a heartened one for me very quickly is that as a sole practitioner, I had to learn a lot. And there's so many different aspects of how a law office operates, from the administrative to the simple housekeeping related tasks. It's definitely a very different kind of existence from that I lived as a partner within a firm. But like I said, it's also an opportunity for tremendous growth.
And I think in thinking about that framework, when a young lawyer or any lawyer is thinking about moving out and starting their own shops, there's often a lot of costs that you don't realize. Even in my firm, in becoming partner and getting the list of the copy machine and the rent and the postage machine and the receptionist, I knew those costs were there, but I didn't realize at the business level how expensive they are. Were there any overhead costs that surprised you when you opened up your firm?
Thankfully, there weren't, because the firm that I had worked at for 9 years before I opened my office was really good about structuring overhead costs for the attorneys, and it ended up impacting our pay to a certain extent because the compensation structure was actually built around overhead. So when I first started, I think overhead was maybe $8,500 a month, and then that was in 2002. And then around the time that I left in 2011, I think it was maybe somewhere in the range of $13,000. Some of that had to do with the fact that we moved into a new building and the partners owned the building, but of course there was a different structure with regard to how we paid for that mortgage. Nonetheless, we always, starting off as associates through becoming partners, knew what the overhead expenses looked like. And I was thankful for having had that understanding as a young lawyer, because when I transitioned to becoming a sole practitioner, I had a sense as to what those expenses were and what areas I might be able to work on in order to reduce overhead, because at the end of the day, my bottom line is impacted by those expenses. So I've tried to identify areas where costs could be better managed. An example would be in an effort to maximize my legal assistant's paralegal's time, signing on for a virtual receptionist service, because we're able to, filter through calls that are coming in and then target when we're making return phone calls, let's say later in the day, so that when she's working on a project in the morning, she's not having to, be pulled aside for, let's say, 15, 20 minutes to, answer a call. So that's one example. Another would be, resources like there's a service online called Upwork It's a site where you can hire freelancers for projects, simple things such as forms or word processing. There are even individuals on that site that do paralegal work. So there are, I think, circumstances where your in-house staff can take care of things, but then there are also, ways within which you can reduce the time that they're spending on projects by signing on for other services. You just need to be innovative and creative on how you're approaching things. It's not always easy, but I think if you look at it from the perspective that there are other opportunities that are out there, you're going to find the resources that you need.
And I guess after all the overhead's paid, then you finally get to take your salary. I know as a young lawyer, especially in New Mexico, where legal rates are pretty low compared to other parts of the country, even compared to our neighboring states, I was surprised. I was happy of the amount I was getting paid, but then once I got my student loan bill, I was surprised at how much my student loan bill was. So can you talk a bit about your experiences as a young lawyer with your take-home pay and managing student loan debt, and how you managed to get all your bills paid?
As with most freshly minted attorneys, I think to a certain extent, I was just thankful that I had a job, and that it was in an area that was of interest to me. So, of course, having worked in a civil defense firm as a law clerk, I knew I wanted to work in a civil defense firm as an attorney. And the job that I first took was with a firm in Santa Fe, and that was in 2001. And I think the starting salary was somewhere in the range of $45,000 plus bonuses. And I found that very quickly to be untenable while trying to live in Santa Fe, which is why I returned to Albuquerque after 9 months. The new firm also provided a salary, which I think was somewhere in the same range, but monthly pay was also augmented by hitting certain billable targets. So the more you billed, the more you made. So I liked the fact that I had more control over what my pay might look like if I was working hard enough. I think in today's economic environment and with our, recent graduates, they are going to be that much more of the mindset that they're simply thankful that they have a place to work. And I think one of the things that is important, regardless of, when it is that you've completed your law school education, is that you develop a plan and make a concerted effort to live within your means as best you can. It's important to prioritize servicing your student loan debt if you're able to stick with, let's say, that 10-year plan, because those 10 years go by fairly quickly. And if you, try to, be good about paying that monthly amount within that time frame, it's going to free you up in a way that I think is going to lend some more flexibility as you start progressing in your law practice. I think you also need to try to avoid the temptation to take on debt too early. I know that, a lot of us, when you're first starting out, you may be prioritizing other things like, I need a vehicle, I need a home. For many, you're starting a family or you have a young family. So you may be distracted from maybe what your long-term goals may be with regard to saving and retirement. But it's important to create strategies for creating financial stability early in your career, because you're going to find that it's going to end up alleviating a lot of the stressors that come along with carrying too much debt. So when you've graduated, finding a financial advisor or talking to somebody who you trust, who's really good at how they manage their finances, is really important. Understanding with regard to, your retirement account, what your maximum contribution can be and what your employer is going to be providing as a matching amount, I think is something that's really helpful. And as you start building, I think you start developing more of an incentive to continue growing in that direction. So if, you're married or you're, in a relationship with someone and you have a partner, whatever the case may be, working together as a unit, if that's the universe that you find yourself in, to develop a joint plan that you're going to have and holding yourselves accountable is something that's really helpful. It's really helpful as well, just in terms of if you're moving in the direction of having your own office, you're going to have to, have sort of the same structure as to how you're going to grow your office and make it be something that's a sustainable kind of practice. So there's a lot that you need to be preparing for. I think that a lot of us, when you first graduate and become a lawyer, you feel like, I made it through those 3 years. I made it through the bar exam, and you can get a little bit too relaxed, but you need to start forecasting what the next set of challenges are going to be, what the next set of goals are going to be, and then readjust and then go after those as your next target.
Thank you for listening. This episode was produced by the State Bar of New Mexico's Member Services Department and Young Lawyers Division. All editing and sound mixing was done by Blue Sky eLearn. Intro music is by Kevin McLeod at Comtech. The views of the presenters are that of their own and are not endorsed by the State Bar of New Mexico. Nothing said in this podcast is legal advice for you.